You might be thinking, how do I challenge this DUI case here in Atlanta? Well, the first step is contacting and hiring a lawyer. Because the law of DUI is complex and technical in nature, it is not something that I would advise you go to court to try to handle yourself. So once you hire a lawyer, that lawyer can first gather evidence on the case using a motion for discovery and open records requests to obtain information such as the citations, accusations, list of witnesses, police reports, audio evidence, video evidence, dispatch communications, and chemical test results. Once that attorney has the evidence in the case, that's when they're in the best position to evaluate the case, discuss it, review it with you, and then begin negotiating the case with the assigned prosecutor, trying to persuade that prosecutor to dismiss the charge or reduce it to some other type of traffic offense that would be satisfactory. How we do that is we use the law, we use the facts, and mitigating evidence. That's the good information about a person. Their family, employment, educational history, lack of a criminal history, civic associations, those types of things that a prosecutor would never know about a person just looking at the case file. If the prosecutor is willing to dismiss or reduce the charges, wonderful. But if not, we're setting ourselves up for a motion to suppress hearing. That is where we get to make legal challenges to the case and how we're able to get even some of these more factually difficult cases worked out to no DUI. It's where we get to make legal arguments to a judge about the admissibility of certain evidence and why that evidence cannot be used against a person, pointing to constitutional violations the person suffered at the hands of the police. For example, if the police do not have sufficient evidence to justify stopping a person, pulling their car over, that can lead to the suppression of all evidence gathered thereafter. If we are successful in our motions hearing, and the judge suppresses evidence, then the prosecutor will have to reassess their case, determining if they can or should proceed on the case knowing that evidence is now unavailable. If the prosecutor comes to that realization, maybe now we're in a better position to negotiate the case. But if the prosecutor still decides they want to proceed on the case, we then can have a jury trial on the case. If the judge issues a ruling denying our motions, we have the opportunity to appeal that decision by filing a certificate of immediate review, which we have to file within 10 days, and the judge may or may not grant that certificate. If they do grant it, that allows us to immediately bring the case up on appeal, even though there's been no trial on the case yet. If the judge denies that, then we would proceed towards trial, and of course, hopefully win that trial. But if we were to lose that trial, we would then appeal it at that time.